Good evening. My name is Avidan Cover. I'm the director of the Institute for Global Security Law and Policy here at the Law School. And I'm very pleased to welcome you all to today's International Law Student Association lecture, co-sponsored by the Frederick K. Cox International Law Center, The Right, Wrong Man, John Demjanjuk and the Last Great Nazi War Crimes Trial, delivered by Professor Lawrence Douglas. I also want to thank a few people who helped make this event possible, particularly Kevin Vogel, president of the International Law Student Society, Nancy Pratt, and other law school staff for assisting in making this lecture possible. You have a number of announcements about upcoming lectures in your binder, so I won't go into those except to say that just tomorrow morning, Dean and Professor Jesse Hill will be speaking at the City Club on issues present and future of reproductive rights. And later this week, on Friday, in fact, there will be an all-day conference on business and the Roberts Courts. So please consider attending those events and other ones over the next couple of months. A few technical notes. This lecture, unlike many that we hold here, will actually be running 90 minutes, with about half slated for Professor Douglas to deliver remarks and the second half to allow for significant questions and answers. A reception will follow in the atrium area. We'll have an opportunity to talk further with Professor Douglas and perhaps purchase his book as well. Not perhaps. Lawrence Douglas is the James J. Grossfeld Professor of Law, Jurisprudence, and Social Thought at Amherst College. In addition to The Right, Wrong Man, his books include The Memory of Judgment, Making Law and History in the Trials of the Holocaust, and The Vices. His work has appeared in leading publications such as The New Yorker, The Times Literary Supplement, and Harper's Magazine. Hannah Arendt famously wrote in her articles and later her book on Nazi Adolf Eichmann's trial of the banality of evil. Professor Douglas will speak on a subject about which many of you in the room today have great familiarity: the trials or trials of John Demjanjuk. In The Right, Wrong Man, Douglas builds upon Arendt's observations on justice, exploring in particular the functionality of guilt and of evil. To explore Demjanjuk's trial and these challenging issues concerning atrocity, the Holocaust, complicity, accountability, fairness, and justice, please join me in welcoming Lawrence Douglas.
Thanks greatly for the kind introduction, and it's an honor to be here at Case Western. I do also want to give a quick little shout out to my former college roommate, Peter Friedman, who's sitting over there. Hi, Peter. Hi. I think you already said that. I'll speak for probably about 45 minutes and give ample time for question and answer. I actually wanted to start this evening's talk with a story about memory. And this story about memory comes from a trial that took place in Hamburg in the mid-1970s. And there in Hamburg in the mid-1970s, prosecutors tried a number of SS officials who had run a camp called Triniki. And this Triniki camp, it was an SS facility that had been located in Lublin, Poland. And during the Holocaust, the SS had recruited about 5,000 Eastern Europeans, mostly Ukrainians, but not exclusively Ukrainians. And these were Ukrainians and other Eastern Europeans who had first been taken prisoners of war by the Germans, but then had taken them out of their prisoner of war camps and then had trained them basically to serve as death camp guards and to perform other auxiliary responsibilities in genocide. There are some seats here in front, so you should be welcome to come down and take these chairs down here. And in helping them prepare for these auxiliary functions in genocide, the camp even had maintained a small population of Jews so that these Triniki trainees could practiced the techniques that the SS were teaching them. And one famous alumnus of this Triniki camp was John Demjanjuk, about whom we'll be talking about more this evening. In 1975, then, German prosecutors tried a handful of SS men who had overseen this camp. And during this trial in Hamburg, a Jewish survivor of the camp recalled that one of the worst of the SS men at Triniki had been a Obersturmbannführer named Klink. The only problem was that prosecutors had never encountered a record of an SS Colonel Klink at Triniki. And in fact, they were perplexed by the name itself, which, even though it sounded German, Klink, it's actually not a German name. And it came out that, in fact, the survivor had confused her former Triniki tormentor with a very different man. And those of you, at least of a certain age, will recognize this man as the bungling, monocled colonel who presided over the fictitious Stalag 13 in the American sitcom Hogan's Heroes. And apparently, in the survivor's mind, the Colonel Klink of the TV sitcom had become the Lieutenant Colonel Klink of Triniki. And she continued to insist that the two, in fact, had looked a great deal alike. Now, I start with this story because, far from idiosyncratic, I actually think it represents a rather crucial problem and a crucial challenge that trials of the Holocaust have faced. And to appreciate that connection, we need to step back and consider how the atrocities of the Holocaust fundamentally challenged and also unsettled certain conventional understandings of criminality and criminal law that at least some of you who are students here at Case Western Law School might in fact be learning. Because I think it's fair to say that conventionally, that is like in a standard law school class, the law construes crimes as deviant acts. That is, these are typically acts that are committed by individuals or small groups of individuals against other individuals. And different legal systems might reach different conclusions about which acts constitute such a deep threat to social order that we call them criminal. But all legal codes that we know of condemn certain foundational wrongs, such as murder. And again, the conventional model that I think we're pretty familiar with, in the face of these foundational wrongs, acts of murder, the modern nation state responds very aggressively. It mobilizes and deploys a rather elaborate investigatory set of practices. It mobilizes its judicial resources, and they're all geared towards the act of apprehending, prosecuting, and ultimately punishing perpetrators. And in fact, even if some of you studied, for example, political theory, you'll know that in the writings of people like Thomas Hobbes and Leviathan, the state is really understood as the bulwark of law and order. That is, the state almost by definition is the force that protects us from the violence of other strangers within civil society. So that's kind of the conventional model. Nazi crimes exploded this model and its ruling assumption that it's private violence that represents the most basic threat to the fabric of social life. Because Nazism revealed the terrible capacity of the state itself to turn reprobate. And this was a phenomenon that the German philosopher Karl Jaspers referred to this phenomenon with the term Verbrecherstaat, which simply means the criminal state. In Jaspers' this term was meant to illuminate how Nazism had in fact turned the state into the principal perpetrator of crimes, that is, the very agent of criminality. So rather than being the bulwark against criminality, the state is now the very agent of it. Now, this posed certain foundational problems, I think, to law and to legal institutions. And in his opening address at Nuremberg, Justice Robert Jackson, who, as many of you know, was leading the American prosecution by taking a leave of absence from his position on the U.S. Supreme Court, Jackson framed the legal challenge posed by the Verbrecherstaat in rather clear terms. He said, and this is a quotation from Jackson, "Civilization asks whether law is so laggard as to be utterly helpless to deal with crimes of this magnitude by criminals of this order of importance." And here, this is just a image of the International Military Tribunal at Nuremberg. At the very top, you see the row of the judges. And of course, this was a trial that was constituted by the Americans, the Soviets, the British, and the French. And the Nuremberg trial, this international trial at Nuremberg, it offered, I think, a distinctive answer to the question that Jackson had rhetorically asked. That is, Jackson and the allies at Nuremberg insisted that law was adequate to deal with the task, the legal challenge posed by the Verbrecherstaat, but that mastering that challenge would require extraordinary legal innovations. And it would require, for example, new jurisdictional principles. It would require unorthodox evidentiary conventions. And most of all, in order to master the challenges, it would require novel categories of wrongdoing. That is, categories or incriminations that would have to be sufficiently flexible and sufficiently capacious to handle crimes that spanned a continent, that had enlisted the participation of tens of thousands of perpetrators, and that had been supported by a complex organizational and logistical apparatus. And of these new categories of wrongdoing, of these new incriminations, two stand out. The first was crimes against humanity, and the second was genocide. The Nuremberg was not, in the first instance, a trial about the Holocaust. In the first instance, the main charge that was brought against the defendants in the dock at Nuremberg, the 21 defendants who were physically present there, was that they had committed crimes against the peace, that they basically had launched an aggressive war in violation of international law. But nonetheless, Nuremberg did offer judicial recognition of crimes against humanity, which was the novel term that the Nuremberg Tribunal used to denote and describe state-sponsored atrocities, and it was largely that category of wrongdoing, that incrimination, which supplied the legal channel or the legal conduit that most of the evidence of crimes against the Jewish population of Europe entered the tribunal at Nuremberg. The second important incrimination was genocide. Genocide is the term that was coined in 1944 by Raphael Lemkin. Lemkin was a Polish-Jewish jurist who, at the time in 1944, was a legal advisor to the U.S. War Department. In 1944, he published a book called Axis Ruled in Occupied Europe. And in this book, in order to try to find a term that would adequately describe what was happening to the Jewish population in these occupied areas, he took a Greek word for group, genos, and wedded it with a Latin term for killing, side, as in like suicide or homicide, and he came up with this new term of genocide. And in his lexicon, according to Lemkin, genocide was meant to denote something more than just mass murder. For him, and this is a quote from Lemkin, it meant to describe, quote, a coordinated destruction of the essential foundations of lives of groups with the aim of annihilating the groups themselves. And at the time of the Nuremberg trial, the time of Nuremberg, We find the prosecutors there using the term genocide. At the time of Nuremberg, genocide is used basically as a descriptive term, as a way of describing the Nazis' crimes against humanity. But a scant few years later, in 1948, the UN Genocide Convention already elevates genocide out of just being a term of description and now has it denote a separate, independent incrimination in international law. And these important legal innovations, such as the creation of these new incriminations, there is a seat right here in front if you like. These important legal innovations ultimately authorized the prosecution of a great many perpetrators of the Holocaust. I think very often there's a temptation to think that very few Holocaust perpetrators ended up ever seeing their day in court, and that's actually somewhat of a misleading statement. There were thousands of such trials, perhaps not as many as we want when you take into account the tens of thousands, perhaps even hundreds of thousands of people who perpetrated and were accessories in the crime. But nevertheless, there were a great many Holocaust trials, and everything from principal architects of the crime to zealous bureaucrats who carried it out, to hands-on exterminators who performed the killing themselves, found themselves at one time or another on trial. But nevertheless, I think it would be wrong to say that these innovations made the trial of Holocaust perpetrators a simple or straightforward matter. To the contrary, I think these trials invariably posed very, very grave problems, and this brings us back to the point of departure, that story that I began with about this mistake of memory. At Nuremberg, the prosecutors decided to structure their case around captured documentary evidence rather than on eyewitness Nazi, that is, instead of on eyewitnesses to Nazi atrocity. The prosecutors were concerned that the stories of Nazi atrocity were so extreme that direct survivor testimony would be dismissed as exaggerated or even fabricated. And so here what you have in this is just, I thought, a pretty revealing image that makes vivid this trial by document at Nuremberg. So here we see, this was the mimeography room of the prosecution, and you can see the tens, in fact, hundreds of thousands of pages of documents that the prosecution prepared instead of relying more heavily on the testimony of survivors. Now, the decision not to call survivors to the stand at Nuremberg, also politics played a role in that decision. The British in particular, the British prosecution was concerned that any testimony that would highlight the specific suffering of Jews would complicate their effort to restrict Jewish immigration to Palestine. And so as a result of that, the British really kind of exercised a lot of influence, making sure that there were no survivors coming to the witness stand. So again, the bulk of the evidence at Nuremberg came in the form of captured Nazi communiques and documents. And again, this material was considered harder and less vulnerable than eyewitness testimony. Now, this trial by document, though, had one dreadful inadvertent consequence because Nuremberg became, and this was the line that was that comes from Rebecca West. Rebecca West is a British writer who covered the Nuremberg trial for the Daily Telegraph. And Rebecca West, she famously described Nuremberg as a citadel of boredom. And what you have to bear in mind is, this is the first international criminal court in human history, the first in human history, dealing with spectacular crimes, and the trial ends up becoming a fantastically tedious affair. She then goes on to describe it as that this wasn't just boredom, this was boredom on a world historical level. And again, one of the reasons that it was so boring is because the prosecutors, in relying on captured documents, what they basically did is they got in front of the court and they read documents aloud. And not only did they read documents aloud, but I guess I should mention, they read them slowly. And the reason they read them slowly is because they had to have them simultaneously interpreted into the other languages that were being used, such as Russian or German or English, French. And so what you had is you had prosecutors getting up there and going, according to Rebecca West, Nuremberg was a citadel of boredom. And this went on for months on end. Now, some of the critics of the trial went much further still. And some of the critics said that actually by not having the voice of the survivors present, what Nuremberg was doing is they were almost inadvertently, what the trial was doing is almost inadvertently completing the project of the perpetrators. This was actually a criticism that came most visibly from groups of Jewish survivors, because they were arguing that by having the victim absent from the trial, what Nuremberg was doing is it was leaving the victims anonymous and erased from memory. That is, again, almost completing inadvertently the work of the perpetrators themselves. If we move from Nuremberg to the Eichmann trial, this is just an image from the Eichmann trial in 1961. Eichmann, who was basically kind of the logistical mastermind of the deportation of about 1.5 million Jews to their death. This is the court in Jerusalem. You can see on the left in the glass booth, in this kind of iconic glass booth, the defendant Adolf Eichmann, the three-judge panel presided on by Moshe Landau in the center, and members of the defense on the left and the prosecution on the right. The Israeli trial, this Jerusalem trial of Eichmann in 1961, it consciously tried to correct Nuremberg's missteps. That is, the Eichmann trial very consciously was structured around the testimony of survivor witnesses. And in fact, the chief prosecutor, I don't think this actually has a pointer, so I'm not even going to try to laser in on it, but if you see on that first row, roughly right in the middle, there's a guy kind of turned a little bit obliquely to the side, and he's got bald, you can see his bald pate. That is the Israeli Attorney General and Chief Prosecutor Gideon Hausner. And Hausner very consciously said that gaining a conviction and securing the death penalty against Eichmann were not the exclusive goals of the trial. That more generally, what he really wanted is he wanted a trial that would galvanize the attention of the Israeli public and that would create a living record of a gigantic human and national disaster. And the key to doing that was to kind of reverse the priority of Nuremberg, and instead of giving the privilege to documents, it would give the privilege to the lived testimony of survivors. And I could have given an image of anyone. This just happens to be one of the survivor witnesses who testified at the Eichmann trial, this Abba Kovner. I'm not sure if that's a name that's familiar to any of you, but he's someone who was a well-known partisan fighter during the war, and then moved to then Palestine at the conclusion of the war, having survived. And he then became one of the leading poets in post-war Israel. And the Eichmann trial certainly succeeded in the goal that Hausner had set for it. That is, his goal was really to rivet the attention of a domestic national audience in Israel. And he, in fact, was completely caught off guard by the success of his prosecutorial strategy. Because not only did the Eichmann trial manage to rivet a domestic national audience, but it really managed to rivet and galvanize international attention, particularly in the United States and in West Germany. And in certain ways, it would not be an exaggeration to say that it was the Eichmann trial that really was a turning point in 20th century understandings of the Holocaust. That is, I think it's fair to say that up until the Eichmann trial, the Holocaust was really understood as perhaps the most regrettable and horrific aspect of World War II. But again, it was still seen as part of the larger horror of World War II. Whereas after the Eichmann trial, the Holocaust starts to kind of almost overshadow the war itself, and the Holocaust now begins to emerge as in academic and also larger public understandings as perhaps the iconic event of the 20th century. Nonetheless, the strategy that Hausner used was not uncontroversial, because certain people wondered whether it was proper to basically treat a trial as if it were an oral history project. And is the criminal trial the proper place for honoring the memories of those who have endured unspeakable atrocities? Some of you might be familiar with this book by the German political thinker Hannah Arendt, the Eichmann in Jerusalem. And that's certainly one of the things that Hannah Arendt complains about and criticizes the trial in that book for basically turning what is a criminal proceeding into something that looks like an oral history project. In my mind, the Eichmann trial actually was incredibly successful in trying to put history and memory in the service of justice and vice versa. But if the Eichmann trial stands out as a very successful wedding of the two, the dangers of this Hausner approach, were dramatically exposed in the other great Holocaust trial that was staged in Israel. And that was the trial of John Demjanjuk that began in 1987. And this is about roughly a quarter of a century after the Eichmann trial. I know some of you are quite familiar with the backstory of the Demjanjuk case. For others of you, you probably are not, so I'll just kind of quickly give you a little thumbnail sketch of it, even though it is a very elaborate story, and that if you have any questions about it, I'd be happy to answer in the question-answer period. So Demjanjuk, he was born in the Ukraine in 1920. In 1941, he was drafted into the Soviet Red Army. In 1942, in the spring of 1942, he was taken as a prisoner of war by the Wehrmacht, that is the Germans, the German army after the German invasion of the Soviet Union. And according to Demjanjuk's own first line of defense basically remained that he always stayed in a German prison of war camp. That is, from 1942, essentially until the end of the war, he remained a prisoner of war. If we skip to the post-war period, right after the war, he ends up in a couple of displaced persons camps in Germany. He kind of bounces around a few of these DP camps in Germany, and he's finally able to immigrate to the United States in 1952, settling, of course, here in the Cleveland area. In 1958, he becomes a U.S. citizen, and he officially changes his first name from Ivan to John. And over the next couple of decades, he works as a machinist at Ford. He settles in the nice suburban area of Seven Hills. And remember, this is a time when unionized UAW jobs basically provided an opportunity for a blue-collar transition to a nice middle-class lifestyle. And he basically goes about assembling a nice middle-class life. He's married and has 3 children. And his legal problems begin in the mid-70s. And this is when American investigators and prosecutors start to cast doubt on what he had done after 1942. And in fact, they receive information suggesting that he had trained at that Triniki camp that I mentioned at the outset, and that thereafter he had served as death camp guard. Now, this information that the Americans ultimately compiled suggested that Demjanjuk wasn't just any old death camp guard, that he was a particularly notorious death camp guard who had earned the sobriquet of Ivan Grozny, or Ivan the Terrible, and that he had served as this Ivan the Terrible at the Treblinka camp. And for example, even if you go back and you read the testimony of some of the survivors of Treblinka who testified at the Eichmann trial, some of the Treblinka survivors at Eichmann, they talk about this legendarily cruel, sadistic, sociopathic guard known as Ivan Grozny. And this is the evidence that the Americans believe they have acquired, that Demjanjuk was this particularly notorious guard. What were the Americans to do with this evidence? Well, for those of you who are studying law, you might know that kind of as a technical matter, because the crimes were extraterritorial, that these were not crimes that were committed against American citizens on American soil, American courts, at least an American criminal court, would have no jurisdiction over the acts that this Ivan Grozny had alleged to have engaged in during the war. But this didn't lead American prosecutors entirely powerless, because one thing they could do is they could bring civil immigration charges against Demjanjuk for basically having falsified information, basically lied on immigration forms, that he should have never been permitted to enter the United States in the first place. And so the idea was to denaturalize him, which is basically what happens in the early 80s. Again, for some of you who are familiar with this, you'll know, of course, that his denaturalization case here in Cleveland was by far the highest profile denaturalization case in American history. And as a result of this, he is extradited to Israel, where he stands trial as this Ivan Grozny. He's convicted and sentenced to death. And his conviction is based almost exclusively on the testimony of survivors of Treblinka, who all swear with absolute certainty to recognize in Demjanjuk their former tormentor, Ivan Grozny. Now, I should mention that the accusations against Demjanjuk, that they were gruesome, but from another perspective, they kind of fit easily into what I described at the very outset of the talk as the standard model of criminality, in that Ivan the Terrible really was kind of your paradigmatic villain. You know, he was your paradigmatic sadist or sociopath, the kind of guy that we like watching movies or police dramas about. So as I said, this guy who, his legendarily sadistic character, is convicted. At least they believe that they have rightly convicted Demjanjuk as this legendary character. His appellate process, this is now, we're now all the way up to the 1990s, early 1990s. The appellate process coincides with the unraveling of the Soviet Union, that is the appellate process in Israel. It coincides with the unraveling of the Soviet Union. And I mention that because what this means is that suddenly both his defense and the Israeli prosecutors and historians suddenly gain access to literally hundreds of thousands, if not millions of pages of documents that have been moldering in KGB files. That is, documents that the Soviets had been unwilling to share with the Americans, had been unwilling to share with the Israelis. And what this evidence makes very, very clear is that the Israelis have convicted the wrong guy. That Ivan Grozny was in fact one Ivan Marchenko. If you look at photos of Marchenko and Demjanjuk next to each other, do they look identical? I think I have to say no. It's not as if they were separated at birth, but they have certain features that are things like they're young men who both have they're both prematurely going bald. So you could imagine how people could make a sincere misidentification of them. And it does appear from this information that this Ivan Marchenko, who was Ivan Grozny, that he was killed at the end of World War II, fighting with partisans in the Balkans. At the same time, though, and this is what makes the whole thing into this kind of legal perfect storm, the evidence isn't entirely exculpatory. Because even if it makes it clear that Demjanjuk had never been Ivan the Terrible, the evidence also makes really rather clear that he had been what we might describe as Ivan the Not So Hot. That is, that he had actually been a death camp guard, not at Treblinka, but at a completely different SS death camp called Sobibor. Now, the Israelis had a very difficult decision to make. They hadn't convicted him as Ivan the Not-So-Hot of Sobibor. They had convicted him as Ivan the Terrible of Treblinka. And moreover, the Israelis now had information that the Americans, even at the time of the denaturalization proceeding, had had some doubts about the Treblinka theory that had never been shared with the Israelis. So the Israelis were not at all happy with the situation. And so they basically say, we're releasing this guy and we're sending him back to the United States. For complicated reasons, he gets his US citizenship reinstated, and then immediately there's a new, fresh wave of denaturalization proceedings against him. He earns the dubious distinction of being the only person in American history to be stripped of his citizenship not once, but twice. And then after that second denaturalization, the question is, where is he going to be tried? Finally, in 2009, he is deported to Germany, and in Germany, he is put on trial and then convicted in 2011 as an accessory to the murder of 28,000 Jews during his tenure at the Sobibor death camp, and he died 10 months later in 2012, 10 months after his conviction in 2011. In contrast to both the Eichmann trial and the Demjanjuk's first trial, and this is just an image of Demjanjuk at the time of his trial in Jerusalem. In contrast to both of those cases, the trial in Germany was a trial almost completely absent survivors, but for reasons very different than at Nuremberg. At Nuremberg, as we saw, the prosecutors were wary about privileging survivor testimony over document because at the time, not that much was known about the crime. Well, by now, a great deal is known about the crime, and yet at the time of this trial, there are only 8 Sobibor survivors left on planet Earth, and 2 of them happen to, shortly before the trial begins, 2 of them come forward now claiming to be able to positively identify Demjanjuk at Sobibor. But the German prosecutors, in response to these 2 Sobibor survivors who express a willingness to fly to Germany and testify, the German prosecutors say, "Nein, danke," because the last thing they want is a repeat of the disaster in Jerusalem. I originally covered this Demjanjuk case for Harper's magazine, and this book is kind of an expansion of that reportage. And I thought maybe I'd just read you just very, very briefly a little bit for describing just the atmosphere of what the case was like on the very first day of the trial. So this is going to be a very brief excerpt from this very attractive book. So this is from the first day of the trial. All at once, the chatter in Gerichtssaal 101, that is courtroom 101, dies down as a door at the side of the chamber swings open. Flanked by 2 medical orderlies and a court-appointed doctor, the defendant is maneuvered into the courtroom in a wheelchair. A sky-blue blanket drawn all the way up to his chin covers his legs and body, and a blue baseball cap juts low over his brow. His eyes are closed, and it's unclear whether he's asleep or just fending off the explosion of camera flashes. Photographers, cameramen, and videographers clamor in front of the wheelchair, shooting away in a frenzy, as if Giselle Bundchen had just sashayed into the Munich courtroom. Demjanjuk's mouth hangs open. He appears to mutter words or moan in pain. Cameras flash. A helpless octogenarian, wheelchair-bound, grimacing before a relentless onslaught of publicity. It is not a sight to burnish the criminal justice system's reputation. Demjanjuk's re-entry into the courtroom after the midday lunch only adds to the carnivalesque atmosphere. Gone is the wheelchair, replaced now by a monstrous orange ambulance gurney. Demjanjuk lies flat on his back, a white blanket drawn, so it appears from my vantage point, over his head. It seems that during the lunch break, the defendant has died. A corpse has been wheeled in to stand trial. Appropriately enough, the rest of the first day is devoted to medical testimony concerning Demjanjuk's fitness to stand trial. Three physicians take their turns describing his various ailments, which include gout, gallstones, a pre-leukemia bone marrow disease, and spinal stenosis, a narrowing of the spinal cord. But all three agree that Demjanjuk is physically and psychologically able to stand trial. The physician's testimony concerning the defendant's basic fitness would be completely unremarkable were it not for the grotesque pantomime playing itself out as a backdrop. For all the while, Demjanjuk enacts a play of mute decrepitude and suffering. His face wrinkles in a silent grimace. He grips his forehead. He struggles to moisten parched lips. He stiffly moves his arms and then opens his mouth wide like a dying elephant seal. Journalists in the room exchange glances. The consensus is that the defendant is faking it. The defense is overplaying the martyr card. Demjanjuk's performance lends new meaning to the term show trial. In the coming weeks, Demjanjuk will remain inert. Baseball cap pulled low over his brow, sunglasses, eyes hidden behind sunglasses. But the grimaces, the frowns of pain, the silent moans will all cease. Someone has passed him the message to tone it down. So, without the voice of survivors, without the testimony of survivors, the Munich trial basically turned into a trial by history. And in a sense, when you're dealing with these state-sponsored atrocities, such as the Holocaust, these large questions of history are inescapable, because these crimes, by definitions, they deal with large communities and actions perpetrated of broad swaths of space and time. So let's look at the role, this kind of strange role that historians played at the trial. I think it would be no exaggeration to say that the judicial determination of Demjanjuk's individual guilt turned on basic answers to large historical questions that professional historians, as expert witnesses, supplied. Now, to appreciate this, we have to understand something about the complexion of the case in Munich. So first, as I mentioned, Demjanjuk was being charged not with murder, but charged with the accessory to murder in the case of 28,000 Jews during his tenure at the Sobibor camp. The fact that he had served at Sobibor was very solidly demonstrated by documents. I don't know if there's anyone who challenged that. I mean, at this point, beyond any reasonable doubt, Demjanjuk served at the Sobibor camp. But that said, prosecutors had absolutely no evidence whatsoever about his particular conduct or behavior. So if we go back to the Ivan Grozny model, we have no idea whether he was cruel or sadistic or anything like that. In fact, we have no evidence about his particular behavior at all. So, how did the prosecutors try to get around the fact that they had no evidence about what his particular behavior was like? Well, they created a theory that was specifically tailored to the realities of Sobibor, and the theory was really quite straightforward. And the theory kind of worked almost by logical deduction. And it basically went like this. It said that all Sobibor guards participated in the killing process, that Demjanjuk was a Sobibor guard, and therefore Demjanjuk participated in the killing process. So again, the reasoning was kind of deductive. So if you accepted the first two premises, his guilt followed lockstep. Now, that minor premise that Demjanjuk had served as a guard at Sobibor, as I've said, very solid documentary evidence demonstrating that. But then there's that major premise that all Sobibor guards participated in the killing process. Now that, in its essence, it sounds like a very straightforward proposition, but really it's a pretty complex claim that really could only be proved by a rather exhaustive historical study, both of practices at Sobibor, and the actions of its Triniki-trained guard force. So here, for example, is this is an image from Sobibor. And one thing that I would hope this image would demonstrate, if nothing else, is that Sobibor was very small. It was a small camp. And if you're wondering why it's in Dutch, the only reason I took a Dutch image of Sobibor is because during the time of Demjanjuk's tenure there, almost all the victims of Sobibor were from the Netherlands. So just in some kind of gesture towards them, I decided to use the Dutch slide of Sobibor. So what did the historians establish about this camp? Well, first of all, that Sobibor was a death camp. Now again, that might not be headline news, but it is important to distinguish between pure death camps, such as a place like Sobibor, and even these hybrid facilities, such as Auschwitz. That is, I think typically when we think of Nazi crimes, our paradigmatic example of a camp is Auschwitz. But the historians, they actually try to emphasize the difference between a place like Auschwitz and a place like Sobibor. In the case of Auschwitz, about 1.2 million people were deported to Auschwitz, mostly, though not exclusively, Jews. Of those 1.2 million, about 100,000 survived. So if you thought of Auschwitz as a disease, if you use some kind of disease model, Auschwitz would be an exceptionally lethal place. That's over 90% fatality rate. Compare Auschwitz to a place like Sobibor, or the three pure death camps that were Sobibor, Belzec, and Treblinka. In the case of Sobibor, Belzec, and Treblinka, about 1.7 million, almost exclusively Jews, were sent to those three camps. Of the 1.7 million who were sent to those three camps, there were 125 survivors, period. And the reason that you even had 125 survivors is because you had basically prison breakouts at Sobibor and Treblinka, where a small number of Jews were kept for the purposes of assisting Nazis and the Triniki men in the exterminatory process. So the other thing that historians established was that, so in the case of some place like Auschwitz, which had both a slave labor component and a killing facility as well, the prosecutors recognized that it was, without additional evidence, it was impossible to say whether any particular guard was necessarily associated with the killing process. But this they contrasted with Sobibor, when they argued that, well, since Sobibor had one purpose and one purpose only, and that was to manufacture corpses, anyone who was a guard was in a sense associated with the killing process. Now that argument itself was then strengthened when they actually studied the actual practices of the Triniki trained guards. At a place like Sobibor, very small, there were only about 15 to 20 SS men at a place like Sobibor, 15 to 20. And there were another about 100 to 120 of these Triniki trained guards, such as Demjanjuk. And one of the things that the historians established is that all the guards, that is the SS men and the Triniki trained guard, they were all generalists. That is, when a trainload of Jews arrived, they would all be mobilized for the purposes of facilitating the smooth operation of the well-oiled killing process, of basically of taking people from the trains and bringing them to gas chambers. Now that historical evidence was essential because, for example, any suggestion that any of the guards had been, say, just cooks or just launderers, that would have weakened the overall prosecution, the overall premise of the prosecution, which again was that all the guards necessarily participated in the killing process. So that by establishing that Sobibor was a killing machine, and that all the guards participated in the killing process, the court was able to conclude that Demjanjuk must have participated in the killing process, even in the absence of any evidence of his specific behavior at the camp. Now that did not completely end the inquiry, because one very important question remained. And the question was, had Demjanjuk served voluntarily? Because one thing, again, we need to bear in mind is this was not a Nazi. This was not a member of the SS. This was not a German. This is someone who had been taken a prisoner of war and basically was a collaborator. Had he then served voluntarily? Here again, the testimony of professional historians didn't simply influence the court's ultimate conviction. I really think it made it possible. That is, without the information these historians had supplied, it would have been impossible to convict. Because one of the things that the historians supplied, and again, I could go into greater detail about this in question and answer, but the historians indicated that of the 5,000 of these largely former POWs who'd been trained at Czerniki, about 1,000 of them deserted. That is, 1 in 5 basically deserted. And presumably, many of them deserted not out of moral qualms with genocide. That is, if you look at the desertion rates, there's a very clear uptake after Stalingrad. That is, at some point, a lot of these guards realized we bet on the wrong horse. That is, it became the decision to collaborate with the SS became a lot less wise of a choice when you could hear Red Army artillery again in the distance moving west. So you have a very large number of deserters. What were the consequences of desertion? Well, here again, the historians were able to offer insight. If you deserted with your weapon, then you were in a heap of trouble, because then the SS assumed that you were going to join the partisans, and that and if you were caught, you were probably executed. But if you left your weapon behind, and deserted and then were caught, then the punishment was far less draconian. Typically was a light punishment, and that a guard then found himself once again quickly recycled back into guard service duty. And from this material, the court concluded that Demjanjuk had had a meaningful opportunity to desert, and that the failure to do so indicated that he had served voluntarily. Now again, we can question this conclusion, though I personally take it to be the right conclusion. But again, that's not so much my point. It's really to show how this remarkable process by which this guilt of the single individual was answered by recourse to this kind of these larger historical patterns. Now, I suppose it's also possible to find this larger process of trial by historical deduction disturbing. So I was in the Munich courtroom at the time of Demjanjuk's conviction, and at that time I heard various expressions of sympathy for the former guard, who after all was 91 at the time of his conviction. And people were pointing out, look, there was never any evidence that he was particularly cruel, or that he was particularly vicious, or that he was particularly sadistic. And then I heard other people arguing, saying, no, 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 don't let that frail old man routine fool you. I bet deep down this guy really was an evil monster. But to my view, both of those arguments miss the point. Because the fact that the Munich court convicted in the absence of evidence of his personal bad acts is what, in my mind, accounts for the rule's importance and even its greatness. Because to convict only in the evidence of proof of evil or viciousness is to treat a Holocaust trial as a garden variety criminal case. That is, it's to treat it in precisely the manner that I described at the outset, in this conventional model in which crime is understood as deviant acts on part of individuals. Demjanjuk's Munich trial, by contrast, understood that when it comes to state-sponsored mass killing, that this kind of mass killing is not simply sociopaths run amok, but it's part of an organized exterminatory process. And when it comes to state-sponsored atrocities, guilt is not to be measured by acts of cruelty or acts of nastiness. Guilt follows function. And that was the simple and the great insight of the Demjanjuk conviction. Thank you very much, and I'd be delighted to answer questions.
Thank you so much, Professor Douglas. So yes, we'll certainly take questions. One thing you need to understand, we need to use microphones for those, so to the extent you have a question, please just be patient until one of the folks gets the microphone to you. We have a question right over here.
Thank you. Thank you, Professor, to your right over here.
Yeah.
I seem to remember during the Israeli trial there were suggestions that some of the documents introduced against Demjanjuk might have been Soviet forgeries for KGB misinformation or other purposes. Could you speak to that?
Yeah. The most important document that was tendered at the time of the American denaturalization proceeding in the Israeli trial was this Triniki identification card. So when Demjanjuk trained at Triniki, he was given an ID card. And the Soviets, in one of the very few examples of cooperation with the United States and the Israelis, had actually supplied the original of this Triniki ID to American investigators and then to the Israeli prosecution. At the time, American investigators and historians, they'd never seen these kind of Triniki cards before. It was really the only one they had really ever seen. And they were kind of like, well, we've never seen a whole lot of these things. We don't know exactly what to make of it. Demjanjuk then tried to bring in certain document experts, even though it came out that these experts had lied about their credentials, but to try to attack the authenticity of that Triniki ID. And then the prosecution brought a number of documents experts who all testified to its authenticity. But then when I mentioned and then basically people were convinced it was authentic, but it still was a somewhat anomalous document because people hadn't really seen a lot of these Triniki IDs. Then when I think I mentioned that during the appellate phase of the trial, suddenly these historians, Americans, Israeli, everyone got access to all this material that had been in KGB files. And suddenly people got access to hundreds of these Triniki ID cards. So it wasn't like they just saw one of them and they didn't know what to. Suddenly they saw, oh, that's a standard Triniki ID. This is exactly what these things look like. And so after that, there was never really, in Munich, for example, the defense made a kind of a gesture towards that earlier claim challenging the authenticity of the Triniki ID, but it basically, by then that document had been one of the most thoroughly examined documents in legal history. And no one could really, at that point, credibly believe that was inauthentic. Yeah.
What was the basis for the Munich court asserting jurisdiction to hear the Demjanjuk case for crimes that took place in Poland? Why Munich as opposed to a Landgericht someplace else in Germany? And as corollary, what was the incentive of the prosecutor in Munich to take a case knowing that he was going to have to apply a really novel legal theory under German law?
Right. So I'll start with the first, the question about jurisdiction. So basically there were really two questions. One question is, would Germany have jurisdiction over the case at all? And then if Germany had the jurisdiction, where could it exercise jurisdiction? And the argument that to deal with the jurisdiction argument, the prosecutors, it gets a little technical, but the prosecutors made two arguments. The first argument was, I mentioned that he was accused of accessorying the death of 28,000 Jews. I mentioned that almost all those Jews came from the Netherlands. About 1,700 of the 28,000 actually had been originally from Germany. So they were German victims. So the court was able to say that if for no other reason, Germany has jurisdiction over this guy because some of the victims were Germans. Now,
which raises the question, they had been denaturalized.
Yes, that's on page 129 of the book. And so you're right to point out certain ironies on the part of the court, and that gets a little bit. The other argument they made was they basically were saying that Demjanjuk had operated under the color of German law. There was basically a German official at the time, which is what other courts had already agreed to. So that wasn't so much a novel idea. The reason he was tried in Munich rather than in, let's say, Frankfurt or some other place in Hamburg is simply because when he was in these displaced persons camps, he'd resided in the Munich area. And so the Munich court that's where his domicile was closely connected. So that's why they chose Munich. Then the very interesting question that you also raised, not to suggest that the first one wasn't very interesting as well, but the question about what were the prosecutors doing? Because there was no doubt that the German prosecutors were taking a big, big risk in this case. One of the things I write about at much greater length in the book is that I think for many of us today, I don't know how many of you have visited Germany. I've spent a decent amount of time in Germany. In many ways, Germany is almost like the poster boy of the country, which has done a pretty responsible job of confronting its past. I remember when we were living there a few years ago, we were living in Berlin, and my son, older son, who was 14 at the time, I said, "Oh, look at that, what's that across the street?" And he said, "Dad, it's just another memorial to atrocity." And so Germany's done a pretty good job with dealing with the legacy. But the criminal justice system has not. You know, the criminal justice system did not compile a particularly impressive record of trying former perpetrators and collaborators. And a lot of people thought, wow, in trying Demjanjuk under a totally new theory, they are really running a high risk, because wouldn't this just be absolutely beautiful for the German legal system in 2009, which is when the trial started, at the end of the whole period of Nazi trials, to end up acquitting this guy, to screw up one last time. And so there were pretty high stakes involved with this. In fact, and I think that's a really important thing to emphasize, because one thing I've also heard people say is, well, isn't it convenient that they came up with this Demjanjuk precedent at the time when everyone was already dead? That basically all the perpetrators and collaborators had largely passed, and I'm exaggerating a bit, but largely that the generation of perpetrators had passed. So it was almost kind of the cynical reading saying, well, of course they changed things once it was safe to do so. But that, again, that assumes that this was done by winks and nods, and that's not how it was done. This was a high-risk venture on the part of certain German prosecutors, and I think it was to the credit of younger people in Germany who were willing to readdress the legacy of previous courts' failures to shape a proper theory for how to deal with these kind of state-sponsored crimes. And for example, the prosecutors there were very young people. You know, they were like in their early 30s. And it was kind of interesting for them. They were like, earlier generation got this wrong, we're gonna get it right. And I think that was a very important, they were motivated also. They really wanted to see the court get this right and to rehabilitate itself.
Hi.
Hi.
My question is, I'm trying to understand as a practical matter,
Oh, sure.
what your final conclusion is about functional stuff. So imagine you and I are in the Army, U.S. Army, and we're sent to help the Turks conquer some part of ISIS territory, Raqqa or whatever, right? You and I are captured by ISIS, okay? And so we are taken to a death camp where there are beheadings and they're killing all sorts of people, right? So we're just guards. Are you telling me on the voluntary issue, if you turn to me and say, okay, Chuck, I'll tell you what we ought to do. Let's desert, leave the weapons here, just like Demjanjuk should have done, right? Mm-hmm. And we'll be free of being accessories to the crime. Mm-hmm. Now, is that really what you're saying we should do if we're in that situation?
Well, again, this is, in a sense, the answer is yes. In a sense, the answer is yes. I mean, the thing about it is that the question is, if you suddenly find yourself in a situation in which you are basically being asked to collaborate in mass extermination, and there's an opportunity as difficult as that choice is, but there's an opportunity. And again, I'm not saying that Demjanjuk didn't face a difficult choice, but I think difficult choices are different than having no choice at all. And I do think it is fair to say that you have a positive responsibility to take yourself out of a situation in which you are an active accessory to mass killing.
But historically, you knew 20% of the people that left their guns behind were okay. Now, you and I and Demjanjuk are with ISIS. We have no idea. But ISIS, I'm inclined to think, is going to kill anybody that deserts.
Yeah, that question is, again, the question you're bringing up right now, and you are, just your name?
Oh, Chuck Weller.
Chuck. So Chuck's question, it's a very important question because Chuck's question was really about, not about historical retrospective knowledge, but knowledge which is available at the time. And what Chuck points out is that, it might be easy for us to say now that, oh, well, 1,000 people deserted, and if you leave your weapon behind, there are no draconian consequences. But that doesn't tell us what Demjanjuk knew at that moment. And it's possible that Demjanjuk thought, I saw someone actually get executed. I didn't realize he took his weapon with him. How was I supposed to know? And at that point, I said, whoa, I don't want that to happen to me. And in that regard, this also brings you back to one of the things I think I said very early on, which was Demjanjuk's first line of defense was always that he had been in a POW camp. And in a sense, that made the work of the prosecutors in articulating this novel theory, it made it a lot easier. Because it is exceptionally difficult to make the following argument. In fact, I would go so far as to say it's incoherent to make the following argument. You can't argue, I never did that, but if I had done it, I did it involuntarily. It makes no sense to do that. In order to make the kind of argument that you're making, that Chuck's making, you have to acknowledge that you engage in the criminal act, but you have to then plead that there were extenuating reasons why you participated in it, and those extenuating reasons rise to the level of involuntariness. You can't make the argument saying that I didn't do it, and if I had, I probably would have done it involuntarily. And I think you're absolutely right. If Demjanjuk had, in a sense, one of the things that, at the time of his trial in Jerusalem, Demjanjuk was quite a garrulous figure. He spoke a lot. He took the stand. He didn't do himself any favors, to be honest. He was not a good witness in his own defense. At the time of the Munich trial, he was completely silent. But if he had come forward and made a statement along the lines of what Chuck is saying, then the argument of the prosecution would have been in big trouble. Yes, you can. All right, should I pick or do you? Oh, yeah.
Just to follow up on that, he was kind of stuck with that total denial position because that's what he had said in entering the country and in his citizenship papers. And so his goal had always been to stay in the United States or to come back to the United States. So he kind of was, there was a lot of talk back then about him making some sort of an admission or a partial admission, especially when he was on trial in Israel, when he could have gotten away with the Ivan the not so hot. But he was stuck with it because he never would have come back to the United States anyway.
That's right. No, you're exactly right. And again, it's one of these things where, and it's not so much kind of like, that he'd already boxed himself into a corner with lies. I mean, it's also exactly your point. I mean, if his goal was to return to the United States, then even acknowledging any kind of service at Sobibor, even if that service had been involuntary, according to the U.S. law, that still would have barred him from returning. I do think that in 2009, he should have realized, and certainly his German lawyers should have realized, that there was absolutely no chance that he was going to return to the United States no matter what. And then that raises other questions as to why is it that he wouldn't back off at that last moment. But one can also construct other statements. I could easily imagine how this guy, towards the end of his life, I mean, one of the things that some of the lawyers said who were representing families of victims at Sobibor said is they basically pleaded with him in Munich saying, please unburden yourself of your guilt. And I think that really presupposed that he had a lot of guilt, which I think is probably wrong. I think probably towards the end of his life, he probably had a lot of self-pity. And probably a lot of the self-pity came from the fact that you have a bunch of people looting a store, and 100 of them make off with televisions, and one person's caught with a toaster oven and ends up and he's the one person who gets caught. And in a sense, that is the position that he was in. Yeah.
Was there
My roommate asked me a question.
Is there anything known about the recruitment process to Triniki of Soviet POWs, and was there any voluntary component in that?
Yeah. So it's a very good question about, in fact, it's a brilliant question. That, yeah. No, it is a good question about how so what happened is you have these Soviet POW camps, and the SS would basically comb through the camp, and they would look very specifically for Ukrainians or Estonians or Eastern Europeans. If you were Russian, they had no interest in you. You were probably going to die. I mean, as many of you who have studied, if you know about World War II, there are astonishingly high death rates for Russian POWs, Red Army POWs. The Ukrainians fared a whole lot better. And basically what they did is they looked for Ukrainians. They worked from the assumption that Ukrainians were anti-Soviet and anti-Semitic. That was a working assumption. And they looked for, Demjanjuk, who's about 6'2", 180 pounds, big, strong guy. And they basically said, you want to stay here or you want to come with us. Now, at that point, would Demjanjuk have known what he was volunteering for? And the answer, to give him the benefit of the doubt, is it's not clear that he would have known. He would have known that he was going to be training with the SS. That's very clear. By the time he got to Triniki, then it became a bit clearer. Because, as I said, there were Jews who were even kept on hand to practicing these techniques on. And then by the time you get to Sobibor, well, then it's obviously clear. But it wasn't necessarily clear from the outset. From the outset, it might have been, from his perspective, it might have been, I'm collaborating with the SS, but who knows? I thought I could have been driving trucks for them at that moment.
Professor, a couple of quick questions. One, were any other Sobibor guards prosecuted by German authorities at any point?
Yeah.
Secondly, can you enlighten us about the role of Jim Traficant, the infamous Ohio congressman who at one point took an interest in this case? And lastly, did you have a chance to talk to any of the American judges, such as Judge Battisti, who was involved in the initial denaturalization case?
Right. Well, unfortunately, Judge Battisti died. Right, so he wasn't, I couldn't talk to him. The one to talk to was Judge Merritt in the Sixth Circuit. But, and Jim Traficant, Demjanjuk had his fair share of supporters. It wasn't just people like Traficant, who then ended up as you're all familiar, probably better than I am, that he then went federal prison, and he had all these other little conspiracy theories about the JFK assassination. And I mean, the butter seems to slip from the noodles a little bit there. I'm not exactly sure what Traficant was. I mean, he was also representing, I suppose, a constituency in which there was support for Demjanjuk. And again, there was, at least in the early phases, that kind of support from Demjanjuk also translated into anti-Soviet, kind of a position of being strong against the Soviet Union. And we find people as well, people like Pat Buchanan, the erstwhile presidential candidate and White House spokesperson, also being a very aggressive supporter of Demjanjuk. I mean, it was Buchanan more than Traficant. I mean, Buchanan went so far as to compare Demjanjuk to Christ at Calvary. And that was a statement that he made not early on. That was a statement he made at the time of his deportation to Germany in 2009. So he continued to be a very, to this day, to defend him. And then the question you ask about other Sobibor guards tried. The Germans did try other Sobibor guards, and this actually highlights some of the problems that plagued these earlier German trials. So in fact, in the mid-1960s, there was a pretty large trial of Sobibor guards that took place in Germany. By Germany, I mean West Germany. East Germany, kind of a separate issue. And one of the SS guards, for example, was this guy, Erich Laux. And Laux was the head of the Triniki Guard Force. So he was, in a sense, the commanding officer, all the people like Demjanjuk. And he's tried. What happens to Eric Laux? Well, he's acquitted. And why is he acquitted? Well, he's acquitted on argument that goes a little bit to Chuck's thing, where it's an argument of necessity and putative necessity. If you look at some of these early German trials, and again, 1960s, I'm saying early, that already sounds a little bit late, but a lot of these German trials were very receptive to what we would describe here as kind of a duress defense. That these guards, even the SS guards, said, I did this because if I refused to participate in these genocidal acts, I would have been in threat of life and limb. And that's why I participated. I was forced to do so. Here again, the work of historians, a tremendous amount of historical energy was then devoted to dealing with the question of the voluntariness of SS officers and German officers largely. And again, one of the facts that I find most astonishing in studies that have come out about Nazi atrocities is the total number of SS men or German NCOs who faced draconian punishment for opting out of genocide. That total number is 0. Historians have never found a single case of an SS person facing severe punishment for opting out of genocide. Do they find cases? Absolutely. You absolutely can find cases of SS people saying, you know, this is not really what I signed up for. I don't like this kind of exterminating people. And was it a good career move? No. If you're interested in advancing in the SS ranks, that was not a swift thing to do. Would it win you the love and respect of your comrades? No. Would it get you branded Jew lover or wimp and things like that? Yes. Might it end up that you'd be then fighting on the front instead of having a cushy job at a death camp? Yes. But the total number of cases that really held up to that claim of duress ended up being 0. But unfortunately, again, it's kind of interesting because you think about a lot of these trials as coming way too late. And yet, it was only decades later that the historical knowledge was put in place that really made possible these convictions. So in a funny kind of way, people like Eric Laux, who were tried in the mid-1960s, they weren't tried too late, they were tried too early. They were tried really before enough of the historical knowledge was acquired that could attack the claims that they were making. Oh, yeah.
I had the privilege of representing John Demjanjuk. I was one of his last lawyers, one of 2. And I also had the privilege of clerking for Judge Battisti right after the Demjanjuk case was. I have to defend my client because under your theory, I think it's the scapegoat theory a bit. Insofar as you note in your book correctly, but I don't think highlight, anyone in this room who would die unconvicted would take offense to everything you said, including the right, wrong man, because after all, he died unconvicted. If I were he and could somehow miraculously come back from life, I would take great offense over this whole situation because after all, your theory posits a proposition that now rests on an unconvicted individual, my former client. But I want to put this in a little bit different context because I think the German courts, which did convict on individual guilt or innocence, had it right. As the prior questioner said, none of us would want to be convicted, I don't think, on a group basis, regardless of the nature of the crime, because no one knows exactly what the duress was. Let's face it. It was a different time in which we all lived. But I think more importantly, individual innocence or guilt is what democracy is all about. Were that not the case, we would get back to racial profiling, social profiling, ethnic profiling, and that's the evil of Nazism. So for the German courts perhaps to lean too heavily on the individual guilt or innocence, the principle on which every democracy is based, I think was a good thing. But I don't want us to forget one thing, and I think this has to tilt the scales heavily towards my client's position. People wonder, well, why didn't you take the stand? Why did you do this? Why didn't you do that? This case started out of him being accused of being one of the worst perpetrators of Nazi Germany. That claim was supported by the top Department of Justice officials in front of a panel one step below the Supreme Court. And that panel of judges, affirmed by the Supreme Court, said, you lied to us. Now, I don't know about the folks in this room who are licensed lawyers, but if any of us had the audacity to lie in front of a Sixth Circuit Court of Appeals, we'd probably lose our license. On that backdrop, the rest of this case proceeds. And I think in that backdrop, that's a really different backdrop. There is a cynical side of me that believes the U.S. government had no choice but to try him on something because they had, after all, spent years trying him on the wrong person. And while you might say, well, the Soviet Union's collapse allowed them to get off the hook, not so. The reason I was appointed to represent John Demjanjuk was because a CNN reporter, after finding declassified information, found a late 1970s and early 1980s documents from our own field office here in Cleveland, Ohio, with FBI memo letterhead right there saying, we think we got the wrong guy. This is not Ivan the Terrible. Now, my question is, the question is, isn't your title revealing the unjust approach? I don't want to be the right-wrong guy ever. I would rather be the wrong guy or the right guy. But the right-wrong guy suggests that there's some shade of gray here between right and wrong. And that's not how our system works. You're acquitted or you're not guilty. But there's no rule that says, but you didn't do it, or you did. And the Israeli court, the Supreme Court's been criticized. Yeah, the Supreme Court's been criticized, and everyone says it was a difficult decision. No, I'm just defending my client here a little bit. The Supreme Court, wait, just let me add this one point. The Supreme Court of Israel's, you mentioned in your talk, made a difficult decision. Why? They acquitted a guy who they thought was innocent. What's difficult about that? So I just want to ask, why the title?
Thank you. There are a number of things I have by way of response. One claim that you made is that, and there are other people who do want to talk, so we have short time, but I hope we get a chance now to move beyond this. Claim that you made is that he was unconvicted. That's a false claim. He was convicted in Germany. He was convicted of being an accessory to the death of murder of 28,000 Jews at his time at Sobibor. So I don't know what you're talking about when you say that he wasn't convicted.
He said he died unconvicted. German law.
No. The technical matter is, he died as this is a technical thing. So
because his appeal was pending when he died.
If I can answer the question. So he died while the case was being appealed. And so as a technical matter, he would be, you could say that the conviction hadn't yet been upheld. That's what one would say. No, one would say that he was convicted. Actually, I probably know German law better than you do. And he was convicted anyway. The fact of the matter is, he was convicted by a German court. The case was never heard on appeal because he died before the appeal was heard. But it's very misleading to characterize the case as if he had been somehow acquitted by a German court. I would also go so far as to say that it's extremely, I think, offensive to describe this person as a scapegoat. That is, one of the things that his defense lawyer in Munich did is he basically said that Demjanjuk was in a position making a duress argument, no different than the Jews who were forced to assist in exterminatory process. The fact of the matter is that these Triniki guards, they were not POWs anymore. These were armed guards. These were guards who outnumbered the SS men at Sobibor by 5 or 6 to 1. They were armed with rifles and in some cases with automatic weapons. They drew pay leave. They drew pay, they drew home leave. They drew medical leave. They received German military burial if they were killed. So the idea that these people were simply elevated Jews is a categorical mischaracterization of the position that they found themselves in. The other thing is, and I think this is the kind of more important point that you made, was about the whole theory, this theory of guilt. And you basically tried to associate it with some kind of racial profiling, which again, I think would create a very misleading picture in the mind of the other people present here. Because the argument that the German prosecution made was not that, well, as an aggregate, these people, we think this person probably did this because other people like him did something like that. With racial profiling, we have no idea whether a particular individual fits this profile or not. We're just relying on larger statistical data. That is not what the argument of the court in Munich was. They weren't relying on a statistical understanding. They were saying, we know that every single guard who participated, who served at Sobibor, had to be an accessory to murder. They had to be an accessory to murder because that was their function. And we have a very detailed historical understanding of what their function was. We know how they operated on 24-hour cycles. Again, we could go into how they got this information, but it was very detailed information about the work that they all engaged in. Then that still leaves open, I suppose, the question of duress. And again, I'm not saying that Demjanjuk didn't face a difficult position, and I'm not saying that had he adopted touch strategy that he might not have prevailed. It's possible he would have. And I also am not trying to guess how I would have behaved in that situation or trying to impugn the character of other people who are thrust into positions like that. But the fact of the matter is I do think that if you find yourself in a position in which you are assisting in the extermination of civilians and in which you have an opportunity, difficult as it may be, to opt out of that, it is your responsibility to do so. Now again, you might disagree with that conclusion, but that's the conclusion that the German court reached, and I think it's probably the right one, the right and fair one. Yeah.
The last question, I'm afraid. We'll be able to take, President Douglas will graciously take other questions at the reception afterwards. This will be the last question for this evening.
Thank you, sir. Yeah,
Sure.
very short. Let me follow Dennis with a bit of a softball. How was the Munich trial handled by the German media? And so far as you could determine, what was the attitude of the German people about the prosecution of Demjanjuk?
Yeah, it's a really nice question because I would say there were probably more doubts about the wisdom of trying this guy who, after all, he was 89 at the time the trial started. He was 91 at the time of the conviction. And probably greater doubts expressed in the American media than there were in the German media. I found that the German media coverage was, first of all, it was quite exhaustive. Again, anytime you're dealing with these kind of spectacular trials, the media coverage follows certain cycles. So at the very beginning of the trial, there's an intense amount of scrutiny. Then as the trial goes on, there's a lull, and then there's more towards the end. But virtually every German paper that I came across, and I tried to certainly read through them, offered very aggressive support of the new theory that had been articulated in this case, and basically offered support of the decision to try him and offered robust support of the conviction. And if there was an element of ruefulness in the coverage in the German media, I would say it went to the belatedness of it. That is, the regret that this theory of guilt following function hadn't been framed by a German court at an earlier period when it could have sponsored more prosecutions. That said, as some of you who are following this closely might know, that the Demjanjuk precedent has been used in basically 3 follow-up cases. So it's not entirely a new theory without any kind of legal legacy. But again, almost what I've tried to say here is the importance of the ruling lay less in the additional prosecutions that it made possible than in getting it right as a conceptual understanding of what guilt means when it comes to state-sponsored atrocity. So thank you very much.
The book is being sold outside. I think Professor Douglas will sign it for you and join us in